Asset protection isn't just for the ultra-wealthy. It's about preserving everything you've built for the next generation. You worked hard to build your wealth. It could be a family business. It could be a lifetime of savings. Now you want to protect it. You want to ensure it supports your family for years to come. This is not just a concern for the ultra-rich. It is a fundamental need for any family with assets. Good planning is about foresight. It is about preparing for the unexpected. Without a solid plan, your legacy could be at risk. The goal of asset protection is to build a shield, a legal framework designed to safeguard what you have earned. Let's start with the basics. What exactly is a trust? A trust is not a company. It is a legal relationship, a formal arrangement to hold and manage assets. Think of it as a secure box. You are the settler. You place assets into this box. These assets can be anything of value: cash, stocks, real estate, shares in your business. The trust legally owns these assets, separate from you. A trustee manages them under a fiduciary duty for the beneficiaries. Why not just hold assets yourself? Trusts offer key advantages: asset protection, control, privacy, and tax efficiency. They allow you to structure your affairs with precision and ensure your wishes are carried out exactly as you intend, long after you are gone. This is where strategic planning becomes crucial. Those are the essentials. A trust is powerful on its own, but its strength is magnified when paired with other legal structures. For Canadian business owners, a common strategy combines a family trust with a corporate structure, an operating company and a holding company. The operating company is your active business. It generates revenue and incurs risks. The holding company does not operate. It holds assets like cash, real estate, and shares. Here is how it works. Family trust owns the holding company. The holding company owns the operating company, forming a multi-layered fortress. If a creditor sues your operating company, their claim is typically limited to assets within that company. Excess cash in the holding company is protected. Because the trust owns the holding company, the structure is further insulated from personal claims against you or your beneficiaries. This structure is not complete without a shareholder agreement, a private rulebook among owners that governs sales, divorce, disability, or death. It can set valuation formulas and rights of first refusal to keep shares from outsiders, and name the family trust as a permitted shareholder. Combined with a trust, it maintains control within the family, manages ownership transitions smoothly, and preserves family control over generations. It is a proactive approach to managing complexity. As a business grows, so does its value. This is good news, but it also creates a growing tax liability when you are deemed to sell at death. An estate freeze caps that future tax by exchanging your common shares for preferred shares fixed at today's value, while new common shares capture future growth. Preferreds can pay steady dividends for retirement security. Low-value new commons can go to children, grandchildren, or a family trust, often with little to no immediate tax. Your tax at death is locked to the preferreds, giving certainty. A trust adds creditor and marital dispute protection and lets you delay naming specific recipients. It is powerful, requires expert advice, and can save a family business from being sold just to pay a tax bill. For some Canadians, financial life extends beyond our borders. A Florida vacation home, investments in Europe, or business interests in Asia. This can lead some to consider offshore trusts, simply trusts established in another country that can help manage foreign assets and navigate multiple legal systems. But using an offshore trust for secrecy is outdated and dangerous. Canada has strict rules about foreign assets and income. A key reporting requirement is Form T1135, the Foreign Income Verification Statement. If you own foreign property with a total cost over $100,000 at any time in the year, you must file it. This includes foreign bank accounts, shares of foreign companies, and real estate abroad. Failing to file, or filing incorrectly, can mean steep penalties, thousands of dollars per year, with increasingly aggressive CRA enforcement and information sharing with other countries. Secrecy jurisdictions are no longer secret. Hiding assets offshore risks penalties, audits, even criminal charges. The message: transparency is not optional. The solution is careful, professional cross-border planning, not secrecy. Work with advisors who know Canadian tax law and the other country's rules. They can structure your affairs compliantly and efficiently, with full disclosure to the CRA. Any promise to hide assets is a major red flag. Proper cross-border planning manages complexity, not evades responsibility. Effective estate planning is not just about transferring wealth, you know. It is about preserving it for multiple generations, the way you envision. A long-term trust sets a roadmap, managing and distributing assets over decades for education, healthcare, and protecting vulnerable family members. Build in flexibility. The world, laws, and your family will change. A trust protector can replace an underperforming trustee or adapt the trust to new tax laws. For enduring trusts, a corporate trustee offers expertise, impartiality, and continuity, with teams in investment, tax, and law to manage the trust professionally. A well-drafted trust can help avoid probate, a process that is time-consuming, expensive, and public. Trust-owned assets pass privately and faster to beneficiaries. Creating a trust is not a one-time event. It is the beginning of an ongoing process. Meet your team, lawyer, accountant, and financial planner, at least once a year to ensure your plan still aligns with your goals and new tax laws. Track the 21st anniversary. Under Canada's 21-year deemed disposition rule, most trusts are treated as if they sold all capital property at fair market value. This can trigger large capital gains, especially for growing businesses or real estate, and can force rushed sales if unplanned. Advisors can act early, distribute assets to Canadian resident beneficiaries on a tax-deferred basis, or plan rollovers to another trust where permitted. Waiting until the 20th year limits options and risks poor outcomes. The key is to act proactively. Liquidity means having enough cash to meet obligations. Estates and trusts can be asset-rich but cash-poor. Life insurance, owned by the trust or corporation, can provide tax-free death benefits that deliver instant cash when needed. That cash can pay taxes and expenses, preserving operating companies and properties for the next generation. A technically perfect plan can still fail if the human element is ignored. Money and family can be combustible. Secrets, misunderstandings, and unstated expectations fuel conflict. Hold a family meeting. Explain why you chose a trust, the roles of trustee and protector, and any distribution conditions. If one child is in the business and others are not, fair may not mean equal. Clarify your logic now to prevent resentment later. We have covered trusts, corporations, estate freezes, cross-border rules, the 21-year rule, and liquidity. The details matter, and the laws keep changing. This is not a do-it-yourself project. Small mistakes can cause large financial consequences and family disputes. Engage an experienced Canadian trust and estate lawyer, a tax specialist or chartered accountant, a financial planner, and a corporate lawyer if you own a business. Together they create a comprehensive plan, legally sound, tax-efficient, financially achievable, delivering clarity, security, and peace of mind. A well-structured plan protects assets from creditors, minimizes taxes and probate fees, and ensures a smooth transition of your business and wealth to the next generation. Begin by organizing your financial information and thinking through your goals for your family and your business. A well-structured trust isn't about secrecy, it's about foresight. Talk to a Canadian trust and tax professional before you need one. With the right team and a thoughtful plan, what you have built can support generations to come.